Welcome, everyone. Thank you for joining us today for this virtual workshop on estate planning. My name is Jonathan Howard, and I am a plan giving counselor here at Concordia University Irvine. I am also an alum, class of 2004. With me today is another Concordia Irvine alum, Mrs. Laura Crawford, class of 2005, who is an estate attorney specializing in setting up estate plans for families with minor children. We will hear from her a little bit later on in this workshop. So why is Concordia offering this estate planning workshop to our local Lutheran churches? Well, in its infancy, Concordia really struggled to keep its doors open. In fact, the only reason Concordia still exists today is because of the financial support of many local Lutheran churches and its donors. And with some ministries and congregations struggling these days, we felt that this was a great way we can give back to those churches and help make sure that they are financially stable going forward. So we're going to talk about estate planning and its ways it can support your families and the ministries that you love. Now, I get it. Estate planning is not the most fun thing to think about. I get it. But it is one of the most important things to think about. And it's really not a subject that you need to spend a lot of time dwelling on either. Most people think that planning your estate is just this long and arduous task that just takes up massive amounts of your time, and that's just simply not the case. And that is why Concordia University Irvine is providing this workshop. We want to educate you on the simplicity of estate planning by walking you through the process step by step, to show you that with a little guidance from us, you can maximize your estate for ministry, for your home church, and most importantly, for your family. So why do we plan in the first place? We're Lutherans, right? We don't need a plan because it's God's plan. Someone once said that if you want to hear God laugh, tell him your plan. So God will take care of everything, right? You know, growing up, I was a worrywart. My grandfather must have seen it in my face because he would tell me all the time, the Lord provides. John, don't worry about it. The Lord will provide. And that was a big comfort every time he told me. Because isn't it a comfort to know that as called and chosen children of God, we know that he has a plan for our lives. And it's a great one. Jeremiah 29:11, for I know the plans I have for you, declares the Lord. Plans to prosper you and not to harm you. Plans to give you hope and a future. This was one of the Bible verses my wife and I chose to have read at our wedding. And in the 11 years we have been married, my wife and I have been reminded of this verse again and again. Simply, the Lord provides. And every time something happens in my life that reminds me of this, it makes me realize that we don't give our offerings to our church or gifts to charity out of obligation or guilt. We give because we want to give, because of what Christ has given us, because of how he provides for us, because everything we have is a gift from God. And we can all give freely knowing that God does have a plan for us, a plan to prosper you and not to harm you, plans to give you hope and a future. So how can we give? Well, there are several ways. This is our giving pyramid. The bottom and biggest part of the pyramid is we tend church and we share our faith with others. Because isn't that what it's all about? Sharing the love and saving grace of Jesus Christ with others. Above that, we can give back by volunteering our time and our talents, because God doesn't just bless us with financial means. He gives us time on this earth and talents we can use to spread the gospel throughout the world. Above that, we have our regular annual giving, and every now and then we are asked to make those special gifts that go above and beyond. Finally, at the top is those estate gifts or legacy gifts. And the only reason this is the smallest part of the pyramid is because you can only make the gift once. But I'm telling you, with proper planning, these are the transformational gifts for your family and ministry. God has placed a gift plan in each believer's heart. They want to give. As our God is a giving God. He gave us the gift of his Son, Jesus Christ, who came to this earth, died on the cross, and gave us eternal life by his grace through faith in him. We are called to be a giving people. In our experience working with God's faithful stewards, we find that they want to give, and they want to give generously. But a lot of the times, they just don't know how. Their plan is a gift from God that just longs for expression. And our job is to help you get that plan down on paper, not to influence you, but to listen to you, your wishes, your desires, and make sure they are communicated clearly for others to understand. So who should I remember? Well, family is number one, as it should be. We make sure your kids, your grandkids, and any dependents are financially cared for. However, after a lifetime of accumulating assets, wealth, and property, is there anyone who thinks it's a good idea for their family to inherit their entire estate? Well, you're not wrong if you feel that way, but I have to warn you, more often than not, leaving your entire estate to your family causes more problems than it solves. We've seen it time and time again. Families can be ripped apart by a sudden income of wealth. Now, don't get me wrong. In most cases, the family is going to still receive the majority of your estate. But since it's a portion of your estate, what portion should they receive? Did you know that there are some assets in your estate that are taxed when left to family and others that are not? So which assets are taxed and which ones are not? I'll cover that when we go over gift models in the next section. Number two, remember your church. It's amazing how often this one is missed. Did you know that no matter which asset is left to your church or charity, it is non-taxable for that organization? That same asset may be taxable for family, but never for the nonprofit. The IRS can't touch 1 cent. Yet, speaking with multiple pastors, the church is forgotten in several estate plans. I have sat down with pastors and asked them, how many church members have you lost over the past year? It normally ranges from 5, 10, 15, depending on the size of the church or the year, really. Then we ask them, how many remembered the church in their estate? The answer is almost always 0. And these are lifelong church members. It may seem like a no-brainer, but when you are called to heaven, your weekly offering stops. Wouldn't it be nice to have your offering continue giving to the church even after you're gone? It's possible. In fact, it's very easy. And I'll cover that in the gift models in the next section too. And third, remember any ministries or charities that are near and dear to your heart. We all have causes that we are passionate about, and that is wonderful. But we encourage you to make sure your family and your church are taken care of first before you look into any other charitable giving. So why do we include a gift to your favorite ministries in your plans? Well, in response to the Lord's love for me, and to bear fruit for the Lord by supporting ministries even after my death. Every church here has outreach programs, and if you are heavily involved in your church, then you may have discovered a passion to further help an organization that your church works with on a regular basis. You also want to leave an example of faith for your family. We can't expect good stewardship from others if we aren't first good stewards ourselves. And most importantly, to be used by the Holy Spirit to tell others about Jesus. The whole point to giving back to your church or a ministry is to help them share the love and message of Jesus Christ to others. So what are your favorite ministries? Well, number one, your local congregation. Make sure your home church is financially supported. Number two, missions. Maybe you have people in your congregation out in the mission field right now, or your congregation supports ministries overseas who are spreading the word of God that you also want to support. Number three, Christian higher education. Maybe you are passionate about supporting the seminary or one of the Concordias. And number four, human care ministries. Those organizations dedicating to helping others in need. So how do we do this effectively? Well, we need to plan wisely. Besides the Christian stewardship ideas we discussed, why is estate planning so important? Well, we want to avoid probate. Laura will go over that. We'll go over probate in more detail in her section. But those who have gone through the probate court process know that it is not fun, easy, or cheap. Number 2, minimize taxes to the biggest charity of all. Who wants to make sure that the U.S. government gets a sizable portion of their estate? Without a plan, they will. Number 3, you, not the state, determines who gets what. I mean, you spent a lifetime accumulating these assets. Ultimately, don't you want to decide where it goes? You get to maximize what the Lord has given you to manage. His master replied, "Well done, good and faithful servant. You have been faithful with a few things. I will put you in charge of many things. Come and share your master's happiness." Matthew 25:23. So 7 out of 10 people do not have a will. And of those that do, they have not updated it for a long time. And really, the greatest enemy of estate planning is procrastination. And we hear all the reasons and excuses for not making a will or living trust. Too busy. It's not nearly as long of a process as you think it is, and we're going to get into that. Well, I have too little property. Trust me, if you live in Southern California and own property, you do not have too little. Too expensive. Compared to the cost of probate court, setting up your will or living trust is very inexpensive. Don't like attorneys. Well, in a few minutes, you'll hear from Laura Crawford. She's an attorney. I like her. I think you'll like her too. The future is too uncertain. What did Benjamin Franklin say, that are the only 2 certainties in this world? Death and taxes. Isn't it funny how estate planning addresses both of them? And my personal favorite, well, I don't plan to die. Well, I guess you got me there. When people give me that excuse and throw logic completely out the window, there isn't much reason to continue the conversation. So you may be sitting there thinking, well, I've never written a will or a living trust. What is that process? Well, the first step is to sit down with a plan-giving professional like myself. Because guess what? The state already has a will for you. It's just not the one that you want. So we will sit with you and develop a plan. We will listen to what you want to do, go over some options on how best to implement those decisions in the most tax-efficient way. We will find you an attorney and help you get ready to meet with them. And if it would be more comfortable, we even offer to go with you to meet with the attorney. You may be sitting there, well, I have a will or living trust. How can you help me? Well, we're going to sit down with you and we're going to review your current will or living trust, because guess what? It probably hasn't been looked at in a long time. We will review your beneficiary designations. Maybe family members that were included have predeceased you, or you've had an addition to the family that you would like to include. We will take a look at your personal property listed in the trust. Maybe you've inherited some property that needs to be included. We will review your power of attorney and your healthcare directive. Maybe the person you want to make financial decisions or healthcare decisions for you right now is not the same person who you listed 15 or 20 years ago when you set up the original documents. We will review your charitable intent. Maybe there's an organization who you'd like to include, or one that you no longer want to support. I'll never forget sitting down with a church member a few years ago and reviewing his living trust. He had 6 ministries listed in his trust that he wanted to remember with a gift. We reviewed them. The first 3 were fine, no problems. The 4th beneficiary was his old home church that had been closed for the past 15 years. The 5th beneficiary was fine. The 6th beneficiary, he looks at it and he says to me, "Who are these people? How did they get in here?" So we will make sure that all of your beneficiaries are up to date. And when we are done, we still offer to go with you to the estate attorney if you are more comfortable with that. So let's talk about this process. What happens in the home visits when you meet with myself or a plan-giving professional? Well, first of all, it's all about you. It's not my estate plan, this is your estate plan. We want to hear your stories, hear what your priorities are. And for those of you who have been blessed by marriage, many times we find that priorities between a husband and a wife are not necessarily the same. It's good to have that discussion. and all the services that we provide are completely free. We do not charge for our time or expertise. We do not require you to remember Concordia Irvine with a gift in your estate. We're here to help. We will leave you with professional proposals that you can take with you to your estate attorney. Our goal is to have your estate plan ready for that attorney in just 2 visits. In our first visit, we will use a wills guide to determine where you are at in your estate planning journey. The wills guide is a great resource to determine your goals, priorities, your assets, and liabilities. We can send you a digital copy or a hard copy before our first meeting so you can have it prepared, or we can take that first meeting and fill it out together. You don't need to get hung up on exact amounts when assessing your current estate, so don't stress. Just ballpark figures will work. We are more concerned about the types of assets in your estate rather than the actual amounts. It is also during this first meeting that we will determine what your goals and priorities are. So it's a lot of information gathering. We will then take this information and come back for a second meeting with personalized gift proposals and options for your consideration. Basically, we are going to show you a couple of ways to leave your gift to family and ministry in the most tax-efficient way. We will also leave you with a planned giving booklet that shares with you many ways that you can support ministry in your estate. And by the end of the second meeting, you should be all set to meet with an estate attorney to make your will or living trust official. So let's take a look at a few examples. So let's first take a look at John and Susan. John and Susan want to leave the bulk of their estate to their family and a bequest to their church in their living trust. And they want to know which assets of theirs should be left to family and which assets should be left to the congregation. And this is where we get into which assets in your estate are taxable for your family and which ones are not. So let's start with the non-taxable assets. Non-taxable assets will include your life insurance, which is always non-taxable for your family. Any bank, checking or savings accounts that you have already been taxed, so when left to family, they will not pay income tax on it. Your house and appreciated investments also are not income taxable. Now, when you sell appreciated stocks or your property that have appreciated, you will be hit with something called capital gains tax. However, when you leave that to your family in your living trust, they receive what's called a step-up in cost basis. So they, when they sell that property, will actually not be hit with the capital gains tax as you would be if you sold it during your lifetime. So all these assets are fantastic assets to leave to the family. Now those taxable assets that when left to family they would have to pay income tax on would be any type of tax-deferred retirement accounts. So 401ks, 403bs, any traditional IRAs. This is money that when you pull it out during your lifetime, you have to pay income tax at the end of the year on what you pull out. Now when left to the family, they also have to pay income tax, which could also increase their tax liability for that year when they receive their inheritance. So when taking a look at John and Susan's estate, we see that their estate is worth $2 million. And we put all of their non-taxable assets together, and it comes to about 75% of their total estate, or about $1.5 million. John and Susan realize that $1.5 million is plenty to be split between their kids and grandkids and any other dependents. And then we take a look at those taxable assets totaling about 25% of their estate. There's 2 ways that they can leave that gift to ministry, which totals about $500,000. They can leave that as a bequest in their living trust, or they can actually change the beneficiary designation with the financial institution who is managing that asset, whether it be Fidelity, Charles Schwab, whoever's handling that asset. It's just a simple form that they fill out to change the beneficiary to their church or ministry that they want to support, and that's a very simple way of leaving that gift to ministry as well. So let's take a look at our next example. Marion. She wants to make an annual gift to her congregation, and she wishes her congregation could continue to receive her annual gift even after she dies. So this is where we had talked about how we can keep that annual gift coming into your home church or ministry even after you've been called to heaven. Well, this is called an endowed gift and a bequest. When we take a look at Marion's situation, every year she has been giving to her congregation about $5,000 annually. As soon as she's called to heaven, without a proper plan, that gift to the church stops. So we set up an endowment for the ministry that she wants to support. Now, an endowment is where you make an initial gift, and that money is never touched by the organization. Only the interest that is made on that gift every year is what's paid out to the institution. So most endowments will pay anywhere from about 3 to 5%, just depending on the year, depending on the organization. So if we take a look at $5,000 a year that Marion is giving to her congregation, she needs to make a gift of about $100,000 in her estate as an endowed gift to that ministry. And if 5% is paid out, that means her $5,000 will continue to come in to support that ministry every year. And that continues as long as that ministry has its doors open. Let's take a look at Harry and Joan. Harry and Joan are in their late 70s, and they could use some additional income. And they have some money in some CDs that they purchased a long time ago that are paying out about 1.5%. Well, if they want to remember ministry as well, they can set up something called a charitable gift annuity. Now, a charitable gift annuity is a contract between yourselves and the financial institution who is managing it. You make the initial gift, let's say Harry and Joan make an initial gift of $100,000 in cash, and charitable gift annuities will pay out a percentage for the rest of their lives. Now, that percentage is based off of their collective age. So Harry is age 78, Joan is age 74. Based off of that collective age and their life expectancy, that charitable gift annuity will pay out 5.1% every single year. A lot better than that 1.5% they were getting on those CDs. After they are both called to heaven is when the remaining balance in that charitable gift annuity goes to ministry. Now, if Harry and Joan both live to their life expectancy, then at their passing, about half of their initial gift will be what's left in the charitable gift annuity to go to ministry. If they live longer than their life expectancy, then a little bit less than half will be going to ministry. If they don't quite make it to their life expectancy, then a little more will be left in that gift to ministry. Now let's take a look at Joe. Joe wants to include a gift to his church now, and he wants to leave a stream of income payments to his son as part of his inheritance. He doesn't want his son to receive all of his estate in one bulk lump sum. So he decides to set up a gift and a charitable unit trust. We take a look at maybe his non-taxable assets or some of his taxable assets, and he wants to make a $100,000 gift to ministry immediately. Then he takes $500,000 out of his estate and he has it fund a charitable remainder unit trust. Now, this charitable remainder unit trust will pay out 5% every single year to his son for the next 10, 20, or the rest of his son's life. You have the ability to choose how long of a term you want that charitable remainder unit trust to pay out to yourself or to a family member. So if we take a look at Joe's situation, he funds his charitable remainder trust with a $500,000 gift, paying out 5% every year for 20 years. That means his son will receive income payments of $25,000 a year for the next 20 years. When that 20 years is over, what is left in that charitable remainder unit trust will then get paid out to ministry. You'll notice on this graph that the amount paid out to ministry is pretty much the same as what gets paid out to his son. Now, a charitable remainder unit trust is also called a give it twice model, because what it does is it takes that initial gift, doubles it over 20 years, and then gives half to ministry and half to family. Finally, let's take a look at Judy. Judy is a widow. She no longer wants to be a landlord because she has a rental property. She still needs the income though, but she wants to avoid capital gains tax that she will pay if she sells that rental property. She wants to make a gift now to her church building campaign, and she wants the remainder of that to go to her church to fund a named endowment. So this is also a gift in unitrust model. She makes that $100,000 gift immediately out of her assets that will fund that church building campaign. Then she sells that rental property for $300,000 and uses it to fund that charitable remainder unitrust. It'll pay out 5% of $300,000, which is a total of $15,000 a year, projected out over the rest of her life. So her rest of her life is projected to be 15.9 years, which means from this charitable remainder trust, she would be paid out a total of $236,841. That's to her life expectancy. If she lives longer, then they'll get paid out more. If she lives a little less, she'll get paid out a little bit less. But once that gift, or once she passes away, then that charitable remainder unit trust will then go to ministry to support the endowment that she wants to have set up. So these are just a few examples on how we have set up a charitable gift model to help the family and ministry. And now I'm going to turn this workshop over to CUI alum and estate attorney Laura Crawford. She will talk to us about the probate process, wills, and living trusts.
Hi, my name is Laura Crawford. I'm an estate planning attorney, and today I will be talking about probate, explaining what it is, why we want to avoid it, and the best ways to avoid it. Probate is a legal proceeding that is used to settle a person's legal and financial affairs after death when they hold more than $166,250 in assets. The advantages of probate: it resolves disputes and debts in an orderly procedure. And that's about it. The disadvantages is it's very lengthy. It usually lasts 1 year or longer. I'm currently representing an estate in probate right now. We filed in January of 2019. It's a simple estate, no creditors, no fights. It was initially set to close in July of 2020, which is already a year and a half, and that's quite a while for a simple estate. And then when you add in COVID and the court closures and delays, it's now set to close January 2022. In addition to that, the administration can be very complicated with probate, and it also can be very expensive. For example, in California, probate fees are set by law and are calculated on a sliding scale based on the probated estate's gross value. It's 4% of the first $100,000, 2% of the next $800,000, 1% of the next $9 million, and 0.5% of the next $15 million. So what happens if you die without having a will? You will be considered to have died intestate. Your entire estate will be subject to probate if you have more than $166,250 in property. Your property will be distributed by statute, which is not necessarily how you might want it to be distributed. For example, I had a client call me to let me know that her uncle had passed away. It turns out that he does not have a will, but he did orally state that he wanted his estate to go to his 2 nieces. Well, unfortunately in California, an oral will is not valid, and without a will, he does have a living sister, and his sister would actually be entitled to the entire estate. So it's really important to have a will to state exactly who you want your assets going to. Finally, your estate could be subject to litigation expenses over fights about where all of your property is going. So can I avoid probate by having a will? No. A will is a writing which nominates an executor and controls who receives your assets through probate upon your death. Having a valid will allows you to distribute your property per your wishes. However, having a will does not allow you to avoid the other disadvantages of probate. So how can you avoid probate? The first way is joint tenancy. The advantage of that is that you will avoid probate upon the death of the first joint tenant. However, upon the death of the last joint tenant, the property will still need to go through probate. Another disadvantage of joint tenancy is that creditors can take jointly held property. A lot of people try to avoid probate by adding a child onto their property as a joint tenant. And while this will avoid probate, it can cause some other issues. Like I said, creditors can take jointly held property. You may think, well, my child is financially responsible, so they aren't going to have any creditors. However, financially responsible kids can still get in car accidents, be at fault, be sued, have a judgment against them, and your property could be used to satisfy that judgment. Another issue with joint tenancy is there can be negative income tax and gift tax consequences. What this means is normally when you inherit a property from a parent, you get a step up in basis, in the cost basis, meaning if your parent bought the property at $100,000 and then the property was worth $800,000 the day the parent passed away, the child would inherit that property, and if they ever sold it, their basis would be $800,000. However, if a child is listed on the deed as a joint tenant, their cost basis becomes $100,000. They no longer receive that step up in basis, and when they sell the property, they can have capital gain issues. Another way to avoid probate is a pay-on-death arrangement. The advantage of this is you can avoid probate by naming the person you want to inherit the assets upon your death. The disadvantage is that it may be difficult or impossible to name a pay-on-death beneficiary for every type of asset you own. Therefore, at minimum, it is still recommended to have a will in place. A pay-on-death arrangement also will not provide for any contingency if your beneficiaries predecease you. The best way to avoid probate is through a living trust. A revocable living trust is a contract entered into by you to establish a separate entity called the living trust, which owns your assets. Your assets remain under your control so long as you are acting as the trustee. Some common terms of a living trust are the trustor settlor, who is the person who establishes the trust. The trustee is the trust manager, and the beneficiary is a person or group that receives the benefits, profits, or advantages of the trust. So when you establish your trust, you actually play all three roles. You are the trustor because you're the person who created it. You are your own trustee overseeing the assets, and you are overseeing them for your benefit. How a trust works is that the trust actually owns the assets, and the trustee manages the property for the benefit of the beneficiaries pursuant to the terms of the trust. A common misconception is that the trustee then also has access to use the trust fund for their own personal use, and that is simply not true. If the trustee is solely named as the trustee, they only manage the property unless they are also named as the beneficiary. A trust will distribute your property according to your wishes, thus acts as a will. A trust will survive your death, which makes it suitable to manage property for extended periods of time after death. With a trust, you are able to avoid administrative fees. It is revocable and amendable so long as you are competent, which allows you to make changes throughout your lifetime. You can also prevent unnecessary litigation by having a no contest clause. No probate is required for trust assets, and therefore you are able to avoid probate fees. You also have the ability to control how property is used and by whom. There are several common misconceptions regarding living trusts. The first is that they are only required for the elderly, and I hate to be the bearer of bad news, but people of all ages can die. Therefore, individuals and couples of all ages can benefit from a living trust. In fact, for those individuals with minor children, a living trust can be even more important, as the trust assets will be held in trust for the benefit of the minor children, supervised by a trustee selected by you. Without having a trust and going to probate, your children will receive an outright distribution at the age of 18, giving your children free rein to spend this money as they see fit. I don't think anyone out there thinks it's a good idea to give $1 million to an 18-year-old with free rein. With a trust, the assets will remain under the management of the trustee until the age you deem appropriate for an outright distribution. Until that time, your trustee can use the assets to support your children pursuant to your instructions. This allows the best of both worlds, where you are able to care and provide for your children in the manner you see fit, and ensure that the trust funds are not wasted. Another benefit of this is when you pass away, your trust becomes irrevocable, meaning that creditors and ex-spouses cannot reach the funds held in an irrevocable trust. The second misconception is that a trust is not necessary if you have a small estate. As stated previously, an estate must have a gross value of less than $166,250 in order to avoid probate. However, the gross value of the estate is based upon the market value of your estate, so your estate may be worth more than you realize. For example, if you have a property that's worth $1 million, yet you have liability of $900,000, you might think your estate is only $100,000. However, probate recognizes it as the fair market value, which would be $1 million estate, and the fees that correlate with that amount will be taken out from your estate. A third misconception is that a trust is not beneficial if you do not own any property and have less than $166,250 in the bank. This statement may be true for certain people. However, if you have minor children, a trust can still be beneficial. Life insurance policies, while not typically subject to probate, can be paid out into a trust and be held for the benefit of your children for as long as you determine. Once again, I think we can all agree, not a good idea for an 18-year-old to be receiving a large lump sum of money. So this is a way to be able to provide and care for your children until the age you deem appropriate. The final misconception is setting up a trust is an expensive and complicated process. This is just simply not true. The fee to set up your trust is much less than the fees that your estate will pay through probate. For example, the probate that I am currently handling has a fairly small estate. It has a property that's worth $700,000 and about $30,000 in the bank. When probate closes, the fee for the attorney will be $17,000. This is significantly more than what it would cost to set up your estate plan. People have the misconception that you're going to need to dig through your old financial records, pull out your last 10 tax returns, and find any type of financial document possible. That is just not true. You simply need to fill out a planning worksheet to the best of your ability. The most important information needed is to know who to name as your trustee, what assets to place in the trust, and how you want your assets distributed. For the process, after you fill out the initial planning workbook, you have a meeting to review the planning worksheet, discuss your wishes, and address any concerns prior to the trust document being prepared. After the initial meeting, I prepare a living trust for your review and signatures, which requires one additional signing meeting, which lasts about an hour. Once your trust is executed, it still must be funded in order for your estate to avoid probate. This is something that is also covered in the last meeting. The fee for the trust also includes a preparation of an advanced estate plan. The advanced estate plan includes a will, a power of attorney, and an advanced healthcare directive. By preparing an entire advanced estate plan, you're not only preparing for your death, but you're also preparing for any emergency where you become incapacitated during your lifetime and are unable to make decisions for yourself. I hope today you learned a little bit about probate, why you want to avoid it, and the best way to avoid it. Thank you.
Thank you, Laura, for that wonderful information on wills, trusts, and probate court. Now let's take a look at one last example before we let you go. This illustration was actually provided by the LCMS Foundation, and so we thank them for this gift model. Let's take a look at Martin and Catherine Luther. We take a look at their entire estate, all their assets and liabilities, and we break them into 4 sections. Going from left to right, you can see real estate and personal property, the first box. Other investments is the second box. Life insurance is the third box. And retirement and annuities is that final box. Now, the big difference between these boxes is the last box, retirement and annuities, is all of those taxable assets that would be income taxable to the family if Martin and Catherine Luther decided to give their entire estate to their family. So we total up all 4 boxes and we see that their entire estate is worth about $2 million. If they give all of that to family, then that fourth box of retirement annuities, which totals $548,000, would be income taxable. Assuming that they are taxed at a 30% interest rate, then the money left to the family would be $1.797 million, and $203,000 of dollars would be taxed out of that family's inheritance. So congratulations, you just gave a gift to Uncle Sam of $203,000, while ministry does not receive any gifts. Now let's take a look at the same exact estate with a plan in place. So we total up all the assets of Martin and Catherine Luther, and they are at $2 million. And what Martin and Catherine decided to do is they wanted to tithe 10% of that $2 million estate to ministry immediately. That is that $200,000 on the ministry side of the illustration. We have taken that $200,000 out of the retirement and annuities box to make sure that that money is not going to the family where they would be taxed on it. Because remember, that gift initially to ministry is 100% non-taxable. Then they've decided to take 40% of their total assets, their non-taxable assets, $800,000, and give that to family immediately. That is their immediate inheritance that they will not have to pay taxes on. Then they've taken 50% of their total estate, $1 million, and funded a testamentary charitable remainder unit trust, and that is that beige box on the ministry side of the illustration. So $1 million over 20 years at a 5% rate is going to pay the family $50,000 a year for the next 20 years, totaling $1 million. So with the initial gift of $800,000 and $1 million being paid out over the next 20 years, the family is receiving an inheritance of $1.8 million. Now, once that 20 years is done, then the $1 million charitable remainder unit trust now goes to ministry. Along with that initial 10% tithe at the passing of Martin and Catherine, ministry is now receiving a total gift of $1.2 million. And you can see right in the middle of that illustration, that red zero, Uncle Sam is not receiving 1 red cent. So with an estate plan in place, Martin and Catherine Luther have been able to provide an inheritance for their family even greater than what it was without a plan, and provide ministry as well. So the question is, what will you leave behind? No matter your age or financial circumstance, you will leave everything behind to people, government, or ministry. Wouldn't it make sense to create a plan to transfer your God-given blessings to the people you love and the ministries you care about? Christian estate planning can seem overwhelming to the point it is often delayed or ignored altogether. Our goal is to assist you in a rewarding and joyful planning experience. We firmly believe that God has placed a unique plan on your heart, and our prayer is that working together, your plan becomes a reality that glorifies Him. Jesus said, "I am the vine, you are the branches. Those who live in me while I live in them will produce a lot of fruit. But you can't produce anything without me." John 15:5. So what do we do now? Well, the first thing to do is pray. Pray that the Lord will work through you to bear fruit. Second, contact either myself or Concordia Irvine's Plan Giving team to set up a personal visit. We can meet in person, over the phone, or even on a Zoom call. We are here to help and to get you started. Here is my contact information along with Laura Crawford's. We look forward to helping you through this important process of maximizing the gifts the Lord has blessed you with for your family and for ministry. Have a wonderful day, and God bless.